editor-in-chief of Revista Argentina de Teoría Jurídica, 1999-2000. He has published many books and articles, and I'd like to highlight at least one: Derecho Privado e Filosofia Política, Fundamentos Filosóficos da Responsabilidade Civil. And I have it here. Another one, Teoria e Crítica do Direito Civil e Comercial. He was just. Today, he will tackle a specific aspect of Jules Coleman's work with the essay that was entitled Coleman on Gap Filling and Default Rules. So, having said that, please join us.
Okay, thank you very much for the presentation, and also thanks to Tordi and especially to Diego for inviting me to this conference. And it's a great pleasure to be here to speak about Professor Coleman's work. I was telling him at lunch that I was the student at University of Toronto, and my colleagues and I from that course remember that course with great pleasure. We have very interesting discussions. And one thing that I wanted to emphasize, and I also find that in the books, is besides your work, which I'm going to talk about now, is your sense of humor. I think that's very something to be said, because as one reads your books and your work, you're discussing.
You laugh.
Yeah. Yeah. But it makes me laugh in the proper
for the right reasons.
For the right reasons. So thanks so much for making this work. When deciding what to write about for this conference, it was a tough decision, in the sense that I thought that most of us would focus on the corrective justice side to the book, and so I said, given that I've written about contract law, why not focus on the first part of the book? So I decided to do that. Though I think there are many questions that the book raises. One, I read your work not necessarily chronologically, but as I got to know the books. So I read this one first, and by reading the book, I thought I wanted to hear more about the methodology of the discussion between or the decision of whether to discuss an area of law from top down or middle up. And by reading Rights and Wrongs, I said, well, I want to hear more about that. And then I came to the practice of prison, and I said, well, this is great. There's more about it there. And so one of the questions that I have about Rights and Wrongs is why, when you discuss contract law, you decided to go through or by the top-down approach rather than the middle up approach. I think you gave reasons in the book, but I think that the corrective justice framework can be very useful as well to understand contract law. So I was wondering, perhaps to discuss later, what you can say about that. So that's one thing that I wanted to discuss, but then I decided to focus on this issue, which is discussed in chapter 8 of Rights and Wrongs, which is the issue of gap filling. And so my comment is rather a challenge, or I want just to raise some doubts about the argument in the chapter. My point of departure is the idea of rational individuals who make contracts. Sometimes, although rational individuals may agree upon having a contract, they may disagree about the extent of the contract or the content of the contract or what their duties are, and that may take them to court. They resolve the issue outside court, but sometimes they go to court. This issue has been, I think, one of the main points that economic analysts of law have made against what we may call autonomy theories of contract law. There's this famous paper by Richard Craswell, where he says that, especially focusing, I think, on Charles Fried's work on contract as promise, saying that the autonomy theories of contract are efficient because they need to be supplemented by something else for most of the issues that come up when dealing with contracts, with, for example, gap filling. And that that critique was, I think, very strong. And I think that Chapter 8 of Risks and Wrongs, what Professor Coleman is doing, is trying to rescue the consent or the autonomy theories of contract law from that type of critique. What he makes is, and he develops an argument in favor of the consent theories by making reference to rational choice theory. And so my doubt has to do with the issue of whether the consent theorist or the autonomy theories actually needs this type of defense. And let me explain why I think that's the case. Professor Coleman's argument in a nutshell is that when the parties have a disagreement about how to go about contingency in the contract that they did not consider explicitly in the contract, a judge has many alternatives. One is to be guided by a sense of fairness and use the fact that the parties have not spoken about the issue to complete the contract in a way that the judge thinks that should have been made to make it fair for the parties. This is one alternative. Another alternative would be to make the contract to create efficient incentives for the future, so use the contract as a tool to provide incentives for future parties. Or they may use default rules. That's another way of dealing with the issue. The problem for the consent theorist is that one way to go would be to for the judge to make reference to the idea of hypothetical consent, but then hypothetical consent is not actual consent. Therefore, the consent theorists may not accept this move. But another move that Professor Coleman makes is to make reference to the rationality of the parties, so that, and I quote, the court complete the contract as the parties would have agreed ex ante. If the contract is a scheme of rational cooperation for mutual advantage, then it should be completed by imagining the terms of a hypothetical rational agreement between them. And Professor Coleman calls this the ex ante contract. My doubt has to do with the idea of what is actually entailed when the parties to a contract provide their consent to be legally bound by a contract. And I think that economic analysis of law, when, for example, Craswell, when they discuss consent theories of contract, make the assumption that whenever something is not perhaps literally or expressly written in the agreement between the parties, we have a gap. We have a contractual gap. And it seems to me that that's not necessarily the case. In fact, the way many contract lawyers actually think is not in that way. That is, many times judges make an effort to take something out of the will of the parties, even though the parties did not say anything about that specific contingency in the contract. And the way I explain my point is by making reference to this very nice example that is used by many legal theories, and I borrow from a paper by Lange, I think that's a way to pronounce it, and Ripstein. And it's this paper where this example when that taken from Wittgenstein, where he says, someone says to me, show the children a game, I teach them gaming with dice, and the other says, I didn't mean that sort of game. And the question is, must the exclusion of the game with dice have come before his mind when he gave me the order, that is the order to show the children a game? And so if we take that example to be an example of a contractual relation, and we change the example a little bit, and we imagine the situation when we have a babysitter and parents asking the babysitter to show their children to teach a certain game, and suppose the babysitter teach the children how to play poker, or some different sort of poker. I would probably say that although that was not expressly stated in what the parents told the babysitter, if the babysitter taught the children how to play poker, she probably, there's a breach of contract there. I mean, it's not, I don't think it's necessary for parents to expressly say that she shouldn't or he shouldn't teach that sort of game, to say that that was included in the agreement. Some people would say, well, no, there's no breach of contract because there was no mention of the type of game that was supposed to be taught to the children. But I think most of us, my students certainly do not see the issue in the same way that I see it, perhaps because they want to say that I'm wrong when I teach contracts, but I think most of us would say that there is a breach of contract there. And so, when we look at what the common law, not necessarily the civil law tradition, at least in the discourse of what lawyers or judges say in the civil law tradition, but certainly the way cases are solved also in the civil law tradition, the idea of the objective approach to contracts and the objective approach to contract making, I think reflects this idea that not everything should be expressed to say that something is part of an agreement. And this is why I say that when concluding agreements, we make reference to a public idea of consent, so that in order to decide whether two parties have a contract or do not have a contract, and as well as to decide what the content of that contract is, we contract lawyers make reference to the reasonable person standard. And we may discuss, of course, what reasonableness amounts to or what that means. But something like that is usually used by the courts. So, to come back to my initial concern, my point is that perhaps some of the concerns that Professor Coleman raises in Chapter 8 of risks and wrongs, I are not the type of concerns that should worry the consent theory of contract law. Because the idea of consent actually covers much of what I think Professor Coleman thinks that covers in Chapter 8 of risks and wrongs. And when we look at commercial practices, and especially in commercial practices, this is what typically courts do when they interpret contracts. Although not all the duties of the parties are strictly written in the agreement, or perhaps it might be just an oral agreement, as usually happens in some commercial dealings, the courts make reference to some standard that in the common law is this standard of the reasonable person, to get to a conclusion that there is no actual gap in the agreement, because the court can take the parties to have meant that they have this sort of duty, or they didn't have this sort of duty, and so on. So my point is that it's not that there are actual gaps, or that there cannot be gaps in contracts, but I'm wondering what is the extent of the critique to the consent theorist in Chapter 8 of Risks and Wrongs. And I say more things in the paper, but I think that's the main structure of my doubt about Chapter 8.
Thank you.
You're welcome.
Thank you. Thank you. Now is Jules Coleman started. As was planned, Professor, you have at least 15 minutes for your considerations.
Thank you.
At least.
Yeah.
Well, we'll see.
It goes without saying.
What?
It goes without saying.
Right, without saying.
Yeah,
Is that the thesis of the paper? All right, so Martin raised two different kinds of questions, and I thank you for both of them. They're both excellent questions. One is about the methodology, and one is about the specific part of the argument. And since I saw lots of people shaking their head yes, in agreement with the methodological point, I think I'll start by discussing the methodology, if you don't mind. So here's, let me backtrack. Because one might wonder why I discuss contract law at all in the book. And so you might say, well, what's the overarching methodology that has me discussing contract law, since I don't know anything about it? So you might say that that's actually the best explanation for why I had a top-down approach to contract law rather than a middle up, because I know a lot about tort law, so I can actually work from the middle, but I know nothing about contracts, so I have to start from somewhere.
You say that in the book. That's what you say.
Did I say that in the book?
Yeah, it's in the book.
Well, that must be right.
Yeah, that's what you say in the book, actually.
Okay,
Yeah.
but we could do better than that.
You say more as well, but that's one of the things.
Oh, really? No, please don't remind me what I said. Okay, so but here's the way I think about it. So, look, at this stage in my writing, what I was still working my way out of is the economic analysis of law. So this may seem odd for a person who was trained as a philosopher, but when I came to the law, substantive law, from economic analysis, because my main teacher was Guido Calabresi. And so I learned the law of torts through economic analysis. And most of my coursework at Yale was by economic analysis. And one way of thinking about tort law, I thought about it anyway, was similar to the way of thinking about contracts. Namely, it's an issue about risk allocation. You don't have to be a defender of economic analysis of law to think about tort law as about risk allocation. In contracts, people allocate risk voluntarily through agreements, and in torts, they allocate risk according to certain norms that assigns the risk. But more than that, general economic paradigm called what I call the market paradigm, which is the idea that law, the way I explain in the book, and I think it's just more generally understood, is that under certain sets of conditions, call them conditions of perfect competition, individuals constrained by very few norms, the norms of no force and no fraud, and more than that a little bit, namely the existence of stable property rights. So if you have norms that establish the existence of stable property rights, and there are norms governing the absence of force and fraud, and then you left people to their own devices, they would secure an optimal outcome or allocation of resources in the core. That's the first fundamental theorem of welfare economics. So that under conditions of perfect competition, we would always reach an efficient outcome. And that efficient outcome would be Pareto superior to wherever we started. And if you didn't like which particular Pareto optimal outcome we reached, you could always redistribute ex post or redistribute ex ante by having a different assignment of initial property rights. So this meant the only reason you ever had any cooperation in the form of a legal order would be under these conditions to put in place prohibitions against force and fraud and to establish initial assignment of property rights. That would be the only point. Now, of course, we have a lot more law than that, right? So the idea was, why else would we have law? The answer would be when markets fail. Because when markets fail, we don't produce efficient outcomes, and so we understand the scheme of cooperation that we call law as a solution to failed competition. And the idea is that the law should produce the outcomes which efficient competition would have produced in the absence of those factors which make competition impossible. The factors that make competition unsuccessful are typically transaction costs. Transaction cost is a black box into which any number of things go, and among the things that go are bargaining costs, externalities, search costs, information costs, you name it, they're all called transaction costs to give them a certain name. Okay? Parallel to economic analysis is actually rational choice political philosophy, which holds many of the same basic tenets. Namely, under certain sets of conditions, rational agents will choose optimal outcomes. The problem is, they won't choose optimal outcomes in the face of transaction costs. The most fundamental transaction cost that philosophers describe is the prisoner's dilemma. And the person they associate this most with is Hobbes. So the state of nature is a prisoner's dilemma, which keeps people from securing optimal outcomes. When do people form states and make states legitimate? To solve this problem of cooperation, of interaction. The logical structure of interaction leads to our explanation of the state. Very similar styles of argument, both in rational choice political philosophy and in law and economics. Both views strike me as mistaken. Okay? But on the legal side, the question was how to respond to it. So the first thing I thought was the argument which everybody knows about competition and cooperation. That this particular picture that gives analytic priority to competition and explains cooperation in the light of failed competition can be turned on its head. And then we can start with the analytic priorities of cooperation among an oligarchy who wants to secure rents. But then they have a collective action problem. How to bargain over these rents and form a stable agreement to distribute those rents. They can't do that because that's a classic case of a bargaining problem embedded in a prisoner's dilemma, and they end up with competition. So competition is a solution to failed cooperation, just as much as cooperation is a solution to failed competition. You shouldn't give yourself the benefit of starting out the way economists do. But let's suppose we give them the benefit. Now, so then we should understand contract law as on this model, namely as a set of rules designed to overcome transaction costs, right? Because all law is just set to overcome certain kinds of transaction costs. So now the question is, when transaction costs are very high, people don't have complete contracts. It's another way of saying the same thing. Perfectly competitive markets yield optimal outcomes. Perfectly complete completing contracts and yield optimal outcomes. What keeps people from forming perfectly complete contracts? Transaction costs. Too much time, too much information, too much whatever, that leaves gaps. Okay? So now the story of gaps is you just replicate the same process. So actually, what goes on in the book on the first part is this. Default rules is the last part, not the first part. It's the last, the transition part. So Martin picked the chapter that's the transition part, not the core idea. The core idea that I developed was that in fact, people already have access to a variety of different kind of tools that are endogenous to their interactions for solving these problems before they turn to the law. So my view was the thought that the law is the first solution in the contract problem is a mistake. That there are a variety of endogenous resources that people can already turn to without having to go to the law. Now, that doesn't mean they won't go to the law. So the question is they go to the law, and the law helps to fill in the problem with respect to transaction costs by gap-filling rules and default rules. Now, before I go further on my methodology, I'll answer respond to your objection. Your objection really boils down to this. You're not establishing for me that there are no gap-filling rules or that my approach to how gap-filling rules should be done is inappropriate. You're just saying that the scope of gap-filling rules is narrower than I think it is because so much of what, when we think there are gaps, there really aren't gaps because of triangulation. Because the actual content of a contract goes much further than what's in the states of minds of persons at any given time. What people actually agree to depends on features of the world and not just things in their mind. And that's called triangulation. And triangulation fills more of the gaps. So what you're saying is, Coleman, you've already narrowed the extent to which we have to rely upon the state to fill gaps in the transaction because you've pointed out all these endogenous resources. I'm pointing out, Martin, an additional resource that you don't discuss, namely triangulation, which will reduce the scope of application for default rules even further. It's not an objection to there being some domain in which default rules have to apply, nor is it an objection to how they should, when they apply, how they should be formulated, right? So my response to you is you're just, and I don't mean just in the critical sense, you're just following up on the general strategy that I've adopted. Because I focused on endogenous resources, you're actually saying there are more than just the endogenous resources that the party have. There is the way the world is. And the problem is in thinking about contracts as a meeting of the minds as opposed to triangulation on minds and world. Right? That's your point. And I completely agree with that point, of course. Because Ripstein, in that article, quotes Donald Davidson. And Donald Davidson was my advisor, so he would have shot me dead if I didn't agree with him on that point. And in fact, he came close to that no matter how many things I agreed with him on. I mean, because he was just that kind of guy. All right, so now that when we've done that, there still will be gaps. There'll be fewer, and we still have to ask the question about how they got filled. So I advance a certain view about how they will get filled that's consistent with what I take to be a certain kind of autonomy theory, which you don't actually object to. What you object to is you think that I think the scope of that is wider than it is. All right. Now, how does this connect to the methodology? This connects to the methodology in the following way. Because if there are any gaps in contracts, and the right way to think about them is to imagine what an efficient contract between the parties would have been, namely what they would have agreed to had there been no transaction costs or the like. You might ask yourself the following question. What is tort law other than a default rule in contracts? That's all tort law is. If this is the way you thought about things, this is how you think about tort law. Why? Because if people are driving cars, we just use an example, and they put other people at risk, in principle, on this sort of picture, the ideal circumstances, now this is not my picture, but this is because remember, from the very beginning, I'm taking the law and economics model, but I don't believe it. I'm just trying to show what an internal criticism of it would look like. If you took this model, you would say, in people driving cars, they're going to put people at risk. They shouldn't be allowed to do this under some set of property rights, or if you thought of this in Coasian terms, they would either be entitled to do this and the pedestrians would have to buy them off from doing it, or they would be not entitled to do it, they have to buy the pedestrians off for being put at risk, a la Coase, right? But they can't do that. But under the ideal circumstances, that's what you'd want them to do, right? Under this picture. Why can't they do it? Because the transaction costs are too high. It's just too hard to find who you might put at risk. And it's also too hard to find who would put you at risk. So, you can't actually, there's a gap in their contract. They can't contract over the terms in which they're prepared to be put at risk by negligent drivers. And negligent drivers can't contact who the people who they would have to pay off to put them at risk by driving and all. So instead, we have a law of torts that does that for us. So the law of torts is just basically one enormous gap-filling rule that responds to various transaction costs that make certain contracts between strangers with regard to the allocation of risk from engaging in certain activities too costly. So that when you think about torts, you should think about it on the model of what rational parties ex ante would have agreed to the distribution of risk with regard to various activities. And if you were an economic analyst of law, that is, you would think of torts as a continuum with contracts. And the device that would play the role, that would be the bridge between contracts and torts, would be the idea of the default rule. And then the whole rest of risks and wrongs is devoted to saying that's not the right way to think about tort law. So the default rule section is designed to play this bridge role between, if you took an economic market view of the allocation of risk, how you would think about tort law. And my whole strategy is to show that first, when it comes to contract law, you have much more resources than you think you do with regard to the need for gap-filling rules. And when it comes to torts, the gap-filling rule picture is not the right picture. And by the way, the whole model starts with the idea that competition is analytically and normatively prior to cooperation, but in fact, there's no reason for thinking that's true, and that in fact, the right way to think about things, if I were doing political philosophy, which I do, to some extent, is it's all schemes of cooperation, and sometimes we cooperate through competition, and other times we cooperate through cooperation, through certain sorts of rules that we adopt collectively, and the question is, what are the appropriate versions of each? And what are the values of each? And then that's why I have the argument about the market, that the best argument for the market is to see it as a scheme of cooperation through competition. And why do we choose it? We choose it as a scheme to cooperate by competing because it puts the least pressure on our shared values. Because we can maximize our interactions with one another in markets without displaying the extent to which we really disagree about fundamental things. Because in order to interact in markets, we have to really have very slight agreement with one another in order to be able to do so. We need a certain degree of civility and a certain degree of respect for property rights and the absence of force and fraud. And we don't have to agree on much else. So in a large liberal political democracy, we want a large realm of our activity handled by markets, not because they're efficient, but because they put least tension on our underlying values. Whereas in the law of torts, we need to have these values actually expressed through our rules. They're not market transactions. In fact, one would say against John, they may not be transactions at all, but that's a separate question. But they're certainly not market transactions if they are transactions. They're forms of engagement. And that engagement requires of us that we determine how we value various activities and the risks that they impose upon others. That's not inescapable. All right. Thank you very much.
Thank you.
services.
You shouldn't have said that.
You-
That
well,
was
in
secret.
fact, I suggested that was what you were trying to do. You should have walked. To think of the things I would say, I might say. Give me more opportunities.
Anyway, we were discussing whether you could say that his idea just reduces the scope of default rules because there are less gaps that we think there are. So in a way, there are no incompatible views, or
Right.
not totally incompatible views. But then one could ask, okay, and for default rules, why necessarily the rational choice approach? Why not also distributive justice approach? You say something on rights and wrongs, and maybe you have the perfect response, but it's not perfectly clear now. It's been a long time since I read that part of the book.
Well, it's been longer
What-
since I wrote it.
Yeah, no. But why not distributive justice too? Or other considerations besides the rational. For example, we could have different approaches to the same problem. We could say that the very idea of a gap is controversial. What is a gap and what is not? A gap is not just an unforeseen event. If it were an unforeseen event that imposed a loss on any of the parties, anything could be a gap, and then we should replace the initial liability rule, the loss for mistake or default, for the rational man approach.
Right. Right.
So maybe I confused two things. One is why not distributive justice, and the other one is why have a conception of gaps, if it is yours, just as unforeseen event and not something like Girona said that this is very unknown in the Anglo-Saxon academic world, but Girona said that the gap is defined by the universe of discourse. So it's not just an unforeseen event, it's an unforeseen event within a universe of discourse.
So here is my answer, which will be entirely unsatisfying. And I don't mean it to be entirely unsatisfying. So after I respond, I'll respond again. That will be less unsatisfying, but not satisfying. All right? So my first response is you might think, well, this is a failure of the book. But and it's a failure of the book in the following way. Why do I adopt what looks like I'm adopting the complete law and economics approach in the first part of the book, and in the other two parts of the book, I'm doing nothing but rejecting the law and economics approach and offering an alternative to it? I must be confused, right? Well, it's very likely true that I'm confused. That goes without saying, and and that would be true independent of this. But I'm not confused in the book, I don't think. I'm not clear enough, maybe. Because in the first part of the book, I'm setting up the second part of the book by playing out the law and economics approach. So I'm working from within the law and economics approach, and I'm not exploring contracts on my own terms. So the notion of gap that I use and the notion of a gap-filling rule that I use are the ones that are within the law and economics tradition, more or less. And I'm using them to show their limitations. And I'm using them as my methodology, which I think is probably objectionable, is because I wanted to set up the book with default rules as my way of introducing tort law, right? And so I was working within the law and economics tradition to show its limitations and then to burst out from it. So every move I make in the first part is, broadly speaking, within the rational choice law and economics framework. And it was really designed to show the limitations of it and the limits of it even on its own terms. And it's much about rational choice political philosophy as it is about rational choice in law and economics. It's really about rational choice. And I this was too strong a way to put it, incoherence to the book. When I think of the book as being unsatisfactory, as of course I do, I think of it as the first part being self-contained and an internal discussion of the limits of rational choice in political philosophy and in law and economics. And the last part on strict liability and torts as an afterthought. Products liability, not my best work. So I think the stuff on products liability is just not my best work. I think the stuff on rational choice is pretty good, but it's not obvious to people what its connection is to the remainder. And it invites questions like this. Why did you consider the rational choice approach to gap-filling rules? Why did you consider a corrective justice approach to contracts? Right? Why didn't you do that? But that's not what I was doing. That's not what I was doing. I was specifically doing if you believed in the market paradigm, you'd approach these areas of the private law in the following way. And start with contracts because that's the paradigm. And this is what you get. So this is how you think about contracts. This is how you think about gap-filling rules. This is how you think about everything.
But you think there's a value to the market paradigm, right?
I do think there's a value to everything, including my own work. Not that much, but I do think there's a value, and the value is this. I was discussing this with John Gardner earlier today, so it's in a slightly different context. I think there's sometimes a value to, well, there are often ideas that are good. There are some, and so the economic analysis idea, the basic idea, is really good. I don't agree with it, but it's really good because it helps organize thinking about a variety of things, and it makes things which didn't seem that important or interesting all of a sudden much more important, and it gives them a kind of significance you might miss, right? And I feel that way about a lot of work. However, and then there's a value that comes from just seeing how that idea gets played out. I think there's an enormous value, not just in the idea for its excitement, but seeing what the world would look like if it got played out according to this. I think the lack of value comes when you claim this is how it really is. That is, it's great to have this idea, it's great to play it out. It's bad to get committed to thinking that the world really is this way.
Or should work this way.
Or should work this way. Yeah. So I think what I was doing was trying to play out. I didn't think I had to play out how the economic story would work in torts, because I'd already done that many times, and there are other people who did it better than me, right? And I've already stood against them. So I think what I was doing was playing out what the economic story looks like in contracts, and identifying what the rational choice theory looks like in political philosophy, and then what the limitations are of it.
Maybe there is, I never saw this way, in the way I'm putting it now, but maybe there is an inconsistency. Why? Because
I don't doubt that.
your contract approach
It's very long
is related to the first part of the book. Actually, we're talking about two parts, but actually there are three parts. It's the political theory in the first part, the contract theory in the second, and the tort law in the third part. So in the first part, you analyze cooperation and the value of markets.
Yes.
Making possible cooperation among different people with different beliefs and everything. So
I think that's
something,
good.
yes, Carlos could explain this in a way. Markets make us sensitive to other people's needs, for example. So I think it's the same idea.
Yeah.
So you could see tort law, or the problem of torts, as some costs of our cooperation, because we live together and we crash with each other. So we need a solution for that problem. But you don't think that way. That would be consistent Why do you have that? Why do we have contracts? Because we value markets in a way. We build our society in this way. Yes, but building our society in this way implies that we're having accidents too. So you take this approach for contracts, but you don't extend it to tort law. So
Well,
that might be.
I do and I don't. I do it de facto by exploring when we have this problem in cooperation, we have to solve it, right? But I think the article that I wrote that does that more directly, sees things more directly in that way, is Mischief and Misfortune. Right. So I think, but the book just goes right ahead and talks about tort law. And I think you're right, it doesn't connect it to the first part, right? It tries to connect it to the second part, not to the first part. But if I did them both, I would have had a different, I mean, I could have written a different book and it would have been better. Maybe. But it would have been different. And once you write a book, you write a book. You got, so the thing is, I always feel in an awkward position. And that awkward position goes something like this. I want desperately always to have a certain distance from the views that I advance. I want to always be able to treat them with a critical eye that other people do. And often I find that, there are issues with them, with what I've said. On the other hand, as a matter of respect, not only to the ideas, but to everybody else who's devoted an enormous amount of their time to my work and my ideas, I owe it to them to try to stand by those ideas. Whether or not, even when I don't fully believe in them, and continue to make the best argument for them, and that's out of respect to others. Because imagine how frustrating it would be for people to work on your work, and you to adopt either of two strategies. You could adopt the strategy we'll attribute to someone who will go nameless, who in jurisprudence says, I was right from the beginning, and I've always been right, and you have me wrong, and you misunderstand me, and you don't understand. Whatever it is you've done, it involves a misunderstanding of a view that seems to have developed dramatically over 40 or 50 years, but was really the same all along. Imagine how frustrating it is to write like that, and because you're always writing with someone in mind, and you're hoping. And the other one would be to write for somebody who says, you're right, but I thought of that before. I've given up that position. I don't hold that position. So I think, if we're adults, we're always trying to think about our views, have them mature and develop, but when other people devote so much energy to exploring your work, you owe it to them to treat your work and own up to it, right? And defend it. Force someone who writes objections to your work to make better objections than the ones they have if you think it's not that good as against what you had, independently of whether you hold that view anymore. So I wrote Risks and Wrongs with a certain set of things going on in my life, intellectually, between trying to figure out tort law, between giving up the annulment conception, trying to find an alternative, thinking about the relationship between corrective and distributive justice, thinking about distributive justice, thinking about law and economics, thinking about markets, thinking about rational choice. At that point, I had just written, I think, one of the really good papers in my life, on David Gautier and rational choice. A critical paper on morality and the theory of rational bargaining. Those things were all on my mind, and this is the way the book came out. And it was okay for me at the time. Substantively, there are things in it which I wish you read things and you say to yourself, gee, I can't believe I wrote so well then. I had so many good ideas. Where'd they all go? And then you read other chat sections and you say, how did I say this? Where were my friends? Why wasn't there someone to stop me from this? And I think it just is what it is. And this is how I saw it. And after you're done, when you write it, that's the end of your control over it. That's the end of your control over it. Other people are invited to read it and to be puzzled as to why it went this way. And all I can do is explain why I did it this way. And what I thought I was doing. And what sense it made to me. And I certainly see it was stupid in some way. It's not stupid, because, but in the sense that if you're defending a corrective justice, you give the impression that you don't have a view about you don't think tort contracts has anything to do with corrective justice. You think it's all about economics. I don't have that view at all. Nowadays, I probably think that contracts is a form of small-scale cooperative activity between parties, right? That's how I probably think of it. I don't think it has to do with promising. I don't think it has to do with, I think it has to do with the forms of social interaction and social engagement for particular kinds of purposes. It should be analyzed accordingly. There's nothing suggesting that in this book. It was how I thought about things then, which I'm not sorry for, but it's just the way it is.
Can I have a short?
Yes, sure.
One short
Go ahead.
response to you about the distributive justice concern was that in my reading of chapter 8, the reason why it was not a good answer to resort to distributive justice, and it was a good answer to resort to rational terms, was that the consent theories would accept rational terms because of the rationality of the parties. So they move from the actual consent to hypothetical consent. It's not problematic because if you take the parties to be rational, then if the default rules are rational, reflect rationality, then the parties would not object to that. But distributive justice would take you to a different domain because the parties would not necessarily accept those terms. If they do, then that's fine. But if they don't, then you have a
Behind the
problem.
veil, they will.
But sorry,
Behind the veil of ignorance,
they
Right.
they
Yeah.
may, yes.
Right. So yeah,
They
you
may,
could.
yes.
But why rational parties and not reasonable parties? You have to assume that parties are reasonable too, not only rational. If they are reasonable, there might be certain, in certain occasions, given an unforeseen event,
Yeah, but
reasons to accept behind the veil of ignorance that the person who is wealthier or richer has to assume the cost in a greater extent.
I think that may make sense, but that's not the approach in the book.
Yeah, no, but the thing was, why not?
Yeah.
Never.
Yeah.
Well, why not? Because it's not the book. I mean,
Really
so
pragmatic.
I agree with that.
So I mean, one could have written another book, which would be the norms governing all areas of the law, because the law governs a group of people, and we have to characterize those people in certain kinds of ways. We should think that those laws should be the laws in terms of norms that articulate or express norms that none of the parties could reasonably reject. And that would be Tim Scanlon's version of this book. Okay?
No, but
And that would be a perfectly good book to write. And,
Yeah,
and there's probably no one who could do a better version of it than him.
it's a legitimate project and it's
It's a perfectly legitimate project, and that
that's
would
my only
reveal a
concern.
lot of things.
Okay.
It would be a really excellent one.
Then we agree.
Yeah. But it wouldn't have been this one.
Yeah, of course.
Because, and it would certainly, and I have another idea, that book would not have been written in 1992 either. Because the idea of reasonable rejection was not fully developed by 1992. So we're using a language now for thinking about this, about the reasonable and the rational, and contrasting them in certain ways.
We can draw these ideas from Ross, I think.
You can draw on these ideas from lots of people, right?
I mean, I just
Yeah.
mentioned Ross because of the impact it has in,
Rawls.
yes, in political philosophy.
Yeah.
I agree.
Okay, we have plenty of time for more like to address latest one?
Is there anybody online who wants to ask a question?
Yes, but not.
Making questions.
Yeah, make questions. At least now.
There's no.
No,
No
no.
questions.
There's no question.
Well, I agree completely that the analysis of contracts feels a little out of sorts with the rest of the book. And if I had to do it all over again, I would have left out contracts entirely. But then I would not have been able to write